Hello everyone, I'm Gauri Kashyap
And I'm Sai Spandana.
and this is SEO Explains. On 11th December 2023, the 5 senior-most judges of the Supreme Court upheld the abrogation of Article 370, which was a constitutional provision that granted special status to Jammu and Kashmir. In this episode, we break down the Supreme Court's judgment.
A 5-judge constitution bench comprising Chief Justice D.Y. Chandrachud with Justices S.K. Kaul, Sanjeev Khanna, B.R. Gavai and Suryakant held that Article 370 was a temporary provision and that Jammu and Kashmir does not enjoy sovereignty and that the President had unilateral powers to revoke Jammu and Kashmir's special status as a full and final step in integration of the state to India.
3 opinions were written in this judgment. Chief Justice D.Y. Chandrachud led the majority on behalf of Justices B.R. Gavai and Suryakant. Justice S.K. Kaul authored a separate concurring opinion, and Justice Sanjeev Khanna concurred with the judgments of the CJI and Justice Kaul.
Let's now dive into the individual questions that the court answered.
CJI Chandrachud held that Jammu and Kashmir did not retain internal sovereignty. He explained that every state enjoys a certain degree of autonomy. However, this was simply a symbol of the asymmetric federal structure of India and not an indication that states retained sovereignty. The special status granted to J&K was simply a higher degree of that autonomy, not a different kind of autonomy. In J&K, he said that after Maharaja Hari Singh signed the instrument of accession, the state became completely integrated with India. Further, the Chief Justice held that the proclamation by Yuvaraja Karan Singh, where he accepted the supremacy of the Constitution of India, all sovereignty was irrevocably surrendered. Justice Kaul took a slightly different approach. He followed the decision of the 1959 judgment in Premnath Kaul versus Jammu and Kashmir, where it was held that the state retained an element of internal sovereignty. Justice Kaul added that as the goal was always complete integration, Article 370 was temporary. The court unanimously clarified that Article 370 was a temporary provision, considering its historical context, wording, and placement in the Constitution under Part 21, which includes other temporary and transitionary provisions. This was contrary to the petitioner's argument that Article 370 had attained permanence after the Constituent Assembly of Jammu and Kashmir dissolved without recommending its deletion. Justices Kaul and Khanna concurred with the Chief on this aspect.
In the course of the hearings, the petitioners had argued that under President's rule, the President cannot take any action that is irreversible. The Supreme Court held that the President's rule is proclaimed only when there is failure of constitutional mechanism in the state. Their actions after the proclamation must have a reasonable nexus with the purpose of declaring President's rule. Judicial review, that is the court's scrutiny, comes in only to test an action that has been taken with malafide or ill intention. No other bar exists on the President's exercise of powers, including the petitioner's argument that the President cannot make irreversible decisions. Similarly, Parliament also has the power to exercise both lawmaking and non-lawmaking powers of the state legislature during the President's rule. The court saw that the state's legislative powers are diminished if Parliament can exercise both lawmaking and non-lawmaking powers of the state. However, Chief Justice Chandrachud wrote that this was necessary under President's rule. CJI Chandrachud held that the President had unilateral power to abrogate Article 370 without the concurrence of the Constituent Assembly under Clause 3 of Article 370. Article 370 Clause 3 states that the recommendation of the Constituent Assembly of the state referred to in Clause 2 shall be necessary before the President issues such a notification. The bench held that the President was not bound by the recommendation of Jammu and Kashmir's Constituent Assembly and did not have the constitutional obligation to consult with the Legislative Assembly. If there was a malafide intent on behalf of the President, the court could review the actions. But in issuing CO 272 and 273, the 2 constitutional orders that abrogated Article 370, there was no such malicious intent by the President. Agreeing with the Chief, Justice Kaul observed that the President could exercise these powers to fully integrate Jammu and Kashmir with the Union of India.
As we just discussed, the abrogation of Article 370 was done through 2 presidential orders, CO 272 and 273. You'll remember that in 272, the Union amended Article 367, which is an interpretation clause of the Constitution, to replace the words Constituent Assembly in Article 370 with Legislative Assembly. The Union claimed that the legitimacy of using this method came from Article 371D, which allows the President to make parts of the Indian Constitution applicable to Jammu and Kashmir. The court held that the President cannot use the interpretation clause to effectively make an amendment to Article 370 without following the procedure prescribed under 370 itself. So that part of CO 272 which changed the interpretation clause was held to be unconstitutional.
However, the bench held that CO 272 as a whole was not invalid. The chief observed that through CO 272, the President essentially made all the provisions of the Indian Constitution applicable to Jammu and Kashmir, a clear and valid exercise of power under Article 370, Clause 1, Subclause D. The effect of this was the same as abrogating the provision using the method prescribed under Article 370, Clause 3. Additionally, CO 272 was not malafide because all the provisions of the Constitution were applied together to Jammu and Kashmir without a piecemeal approach.
In its assessment of the second constitutional order, that is 273, the bench found it to not be unconstitutional because it was the culmination of 70 years of collaborative efforts to fully integrate Jammu and Kashmir into India. The cumulative effect of these two orders, which is to have the Constitution of India fully applicable to Jammu and Kashmir, the Constitution of Jammu and Kashmir itself was now held to be inoperative.
Petitioners had argued that the J&K Reorganization Act of 2019, which divided J&K into the Union territories of Jammu and Kashmir and Ladakh, was unconstitutional. They argued that first, CO 272 took away the need for the approval of the J&K Legislative Assembly to reorganize the territory. Second, the 2019 Reorganization Act changes the character of the state by reducing it into a union territory. On the first issue, the court held that the opinion of the legislature for reorganizing a state is not binding on the union parliament and is just recommendatory. They held that the act cannot be unconstitutional on procedural grounds as the state legislature's concurrence does not bind the union.
The court, however, steered clear of analyzing the constitutionality of the Reorganization Act itself, especially in light of assurances from the Solicitor General, Tushar Mehta, that statehood to Jammu and Kashmir will be restored soon. In the context of Ladakh, the court upheld the validity of the decision to carve out Ladakh as a separate union territory under Article 3A. The question of reducing a state into a union territory, which is what happened with J&K, was left unanswered.
The court, however, was sure to direct the Election Commission of India to conduct elections in the State Legislative Assembly of Jammu and Kashmir by 30th September 2024.
In the concluding pages of his judgment, Justice Kaul penned an emotional epilogue. He recommended that the Union set up a Truth and Reconciliation Commission, just like South Africa did in its post-apartheid era, to address the human rights violation perpetrated by both state and non-state actors in Jammu and Kashmir.
This brings us to the conclusion of our explainer. Do let us know what your thoughts are on the judgment. We at SEO have broken down the 476-page judgment in our summary and matrix. Make sure you check them out. As always, stay tuned to SE Observer for more stories from the Supreme Court.